Hello, veterans, dedicated VA employees, and everybody watching. Welcome back to the Veteran Lang YouTube channel. I am your friendly neighborhood VA accredited attorney, Matthew Lang, here to talk about some more VA disability so we can be more educated to make a process smoother in the future between VA and veterans alike. So, in our last video last week, we talked about deferred decisions. So for this video and this topic, I wanted to carry on with something similar to that deferred decision, veterans, that you will likely have seen more than once when filing a higher level review or an HLR appeal. And that's that duty to assist error. When that decision comes back and says duty to assist error has been found, what does that mean? So let's talk about that today. Ultimately, what this means in short is the VA has failed to fulfill its legal obligation to help you veterans gather the necessary evidence to support your disability claim. This error is a serious procedural mistake that can lead to an incorrect denial, and usually does, or an improperly low rating. Now we're going to repeat some of that just to make sure we've got it as we dive a little deeper into answering the question of what is the VA's duty to assist. Well, the VA has a fundamental legal responsibility to assist veterans in developing, well, your claims, veterans, for benefits. This is primarily found in the Veterans Claims Assistance Act of 2000, also known as VCAA, which is amended 38 USC section 5103A. So veterans, in those letters you get, you may see it called VCAA, you may see it called 5103. But this is ultimately where the duty to assist resonates in the law. And here's what it generally requires the VA to do. Notify you of required evidence. So the VA must inform you veterans that evidence is necessary to substantiate your claim and distinguish between evidence you are responsible for providing and evidence the VA will obtain. Again, this is underneath the 38 USC 5103. You may even see the VA attempt to follow through with this notification by sending you a catch-all letter that could look very confusing at first because it's asking for things that you may have already submitted. So veterans, if you are confused by as such, I would definitely seek clarification. Usually having a representative on your file that you can work with, such as myself, a VA accredited attorney, perhaps a VSO, or another VA accredited attorney, or a VA accredited agent. If you would prefer to work with myself or talk with me to see if there's something we can do, though, to help you understand the correspondence that is being received and making sure all the evidence is submitted for your claim, please go to veteranlang.com to schedule your free case evaluation, either through the button on our page or giving us a phone call there with the number that's on our page. All right, enough of that. Let's continue on to what some of these duties generally are. The VA also has to obtain federal records. So the VA must make reasonable efforts to obtain relevant federal records, such as, well, veterans, your military service treatment records, or perhaps even your service personnel records. The VA also has to obtain your VA medical records, if there are any. They got to pull them in from the hospitals and the clinics and put them into your file. They also must continue to request these records until they're obtained or it's reasonably certain that they don't exist or further efforts would be futile. That's another important part when coming to the duty to assist in obtaining federal records. And we'll talk a little bit more about that in our common types of duty to assist errors, so hold on to that one. VA should also obtain private records. So veterans, if you've identified relevant private medical records or other non-federal records, the VA must make reasonable efforts to obtain them. Now, this usually involves an initial request, at least one follow-up request, provided you've given them sufficient evidence or information to locate the records and authorize the release. So what I have to point out here is that the duty to assist to obtain private records is on the books, but it is limited. Ultimately, the VA only has to make reasonable assistance. One, twice, and then the rest is on you, veteran. Another, and our last general requirement under the duty to assist is to provide a medical examination or opinion, a CMP exam or a VA exam. If the evidence of record is insufficient to make a decision on your claim, veterans, and there's competent lay or medical evidence of a current diagnosed disability or persistent symptoms, the VA must provide a medical examination or obtain the necessary medical opinion. Sure, there's some more evidence likely to take into consideration there, but in short, that's the duty given to the VA. So with these duties in mind, let's talk about some of the common types of duty to assist errors and why, veterans, you may be seeing those duty to assist error decisions. So as we've mentioned, when you see the duty to assist error on the decision, it's indicating that the decision review officer has found that the VA has one or more duty to assist obligations that were not met, and therefore the claim must now go back to the development, ultimately dropping it to a supplemental claim in order to fulfill the legal obligations of duty to assist. So common type number one we see is the failure to obtain medical records. Let's go back to that idea of the private medical records there, veterans. As we mentioned, there's usually at least a couple attempts that are required by the VA to obtain those medical records if the sufficient information and proper authorizations have been given to the VA by you. But what we may see is it gets completely overlooked in the file that the authorization and the information is there and the attempt was not made. Maybe what we'll see is one request was made, but that second one that's required was not made when the records were not obtained off the first request. Sometimes what we see is the failure to obtain the VA treatment records. The VA, again, has a duty to assist by obtaining federal records, and the VA treatment records are federal records. And so prior to sending that claim to, say, the RVSR originally, before it became a higher level review, maybe that BSR failed to provide the most recent VA treatment records that were crucial to granting the claim, and the claim got denied and now became a higher level review, and that DRO, or decision review officer, has realized that those records were not obtained. So a duty to assist to send the claim back. Those are a couple of examples of your medical records issues there. But the biggest one that we face really comes in the next two here I have on my list. Inadequate CMP or VA exams. So the VA should have ordered an exam in this case, which they did, but it was incomplete. It's based on insufficient information, perhaps, or it failed to address the conditions claimed. Many times what we see here is it's the medical opinion or the nexus in itself that is inadequate or insufficient underneath the rules, the guidelines, the laws, and the court precedent. So VA, one thing I want to put here to help you out and in caution, as I know when you receive your training, it's easy to understand the training to say, as long as the box is checked, less likely than not, it's a denial. However, the rules show that we need to have a proper rationale that goes with that checkbox. So to just go ahead and deny because the box is checked would be improper if the rationale does not meet the legal requirements. For example, the rationale may be all conclusionary statements. It may rely on the absence of evidence in service treatment records, or it may fail to adhere to medical literature that the medical community at large would say would link the condition to service. These are just examples of an insufficient medical opinion, ultimately leading to an inadequate VA exam or C&P exam. And perhaps what we see now is the decision review officer will catch that and send that back down underneath the duty to assist. The other type of duty to assist error that is very similar to this inadequate C&P or VA exam would be the failure to schedule a C&P exam or VA exam. Unfortunately, I see this quite often, and we do our best to try to cut it off at the head before the claim does get decided early on by indicating that the criteria for the exam is met underneath the evidence and no such exam has been requested but should be prior to a decision. So ultimately, the VA at this point, veterans should have scheduled or ordered the exam underneath the criteria and the rules, but they did not, and then the claim got denied. Sometimes we may see a reason for a duty to assist error to also be the failure to provide proper notice. This is usually when the VA did not inform you clearly, veterans, about what evidence was needed or what they would try to obtain on your behalf. Then the example that comes to my mind for this one would be, let's say, veterans, you provided a VA form 21-4142, an attempt to give authorization for the VA to obtain private medical records. However, there is a second part to that form, a 21-4142A, that perhaps you forgot to include, which would be required for the VA to follow the duty to assist and obtain those private treatment records. So in this case, the example would say that the VA should have sent you a notice that that form was incomplete. We see that you are trying to have us a VA to obtain these records, but VA at this point needs you to provide this other piece of evidence or ultimately provide those records yourself. And if that notification again did not go out, that could be a type of duty to assist error. Those are the main common ones as I look at my list here that I'd want to talk about today that we see back here as common types of, again, duty to assist errors. Are there more? Sure. But I'm hoping that this gives you the idea of what the duty to assist error is, what the requirement is of the VA, of you even veterans, and what some of those common types are to why you get a decision that says a duty to assist error has been found. The last question I want to answer, though, that comes to mind that I get a lot is, well, what happens now? What happens next when a duty to assist error has been decided or identified? Well, in essence, it works very similar to the Board of Veterans' Appeals remanding a claim to the VA Ultimately, the claim is sent back now from the HLR lane back down to the development world of the VA. In this case, a supplemental claim, or supplemental claim lane, I guess you could call it. So your claim now, veterans, has went from an HLR to a supplemental claim for the development to occur, as new evidence can only be obtained underneath the supplemental claim. It is taken back down through the VA to the VSR to follow the instructions provided by the decision review officer in order to complete the VA's duty to assist. From there, a decision is made underneath the supplemental claim, giving you veterans the opportunity to file another higher level review on that claim if necessary, or another supplemental claim, or an appeal to the Board of Veterans' Appeals. But in short, that's what's happening. Your claim is now being developed accordingly in order to fulfill the duty to assist errors, and a new decision is being rendered. With that, everyone, I thank you again, as always, for being here at the channel, for learning more VA disability with me, for taking in the information I have to share from all of my experience, and for all your comments. I look forward to more, especially if you have topics you would like to hear more about or learn more about. At this point, I do know I still owe another one from a comment. That's going to take a little bit more time to build because I want to make sure we get it right and it's fully understood, just due to the sheer size of the topic. But with that, thank you again, and I'll see you next Tuesday. Have a wonderful week.